As I was recording my 1 millionth, that might be an exaggeration, Blue Apron ad, I didn't feel annoyed. Not only do I hear them and other sponsors like Stamps and Harry's and Chatbooks on my shows, I subscribe to all of them, and they play a lot on my favorite podcasts. But I smile every time I hear them, because they get it. Our sponsors want to make podcasting sustainable, and I want to keep making podcasts. Wait until you hear about the next case. So I want to make this Sponsor Appreciation Week. If you shout out any of the ads that you've heard on this show, or Actual Innocence, or Cold Case Files the podcast, and thank them for sponsoring the podcast you listen to, screenshot it or send me the link via email with your address, and I'll send you a sticker for that show. You can get up to 3 stickers for the different shows, but only one time. So please send the email all together. I'll put their social media links in the show notes. The offer's good until I run out of stickers. All right, on to the show.
I remember Christina Gutierrez hollered at me because I told her, I said, there's so much going on in this case, it just doesn't seem real. And she's like, well, open your eyes, stop being a baby, this is real, this is life. And I said, but it's not your life. You know, it's just crazy. I can't imagine how Richard sits there sometimes. He must just play this in his mind and be like, what the hell is going on? It's almost like we're in an alternate universe and nothing makes sense. And that's what we're living in. Because I look at cases day in and day out, and I see how things go, and it's I don't know. I always say there's just something behind the scenes that's just keeping this thing going, and I don't know what it is. At first, I thought it was just, politics, keeping Jessamy in office. The more wins you have, the better for you when you're a state attorney. But it just does not seem to be going any better. When all this happened, they weren't trying to find who really did it. They had circumstances that had my brother at the scene, and they had a dead baby girl, and that was high ratings in the news for the state's attorney. I mean, that was big stuff. So it just seems like it's just continued on that way. I don't know. It just seemed my brother he's just been high ratings for everybody, and that's what keeps him in prison. It's just the fact that this was such a high profile case. It's just incredible.
Thank you to everyone who's donated to the fund so far at convictedpod.com/support. I still have some swag left though, so I'm extending the deadline to September 11th. If you send me a screenshot of your donation to Richard's Legal Fund and your address, I will send you some swag at convictedpod.com/support. In episode 6, Richard Nicolas was convicted of murdering his daughter. In episode 7, we talked about faulty science and unethical evidence used or not used during his trial. Today, we're going to talk about what you do when those things co-occur, what a person does when they feel like they've been wronged in some way by the system. It's what someone does when they don't want to spend the rest of their life in prison. They appeal. The thing about appeals are,
in the state court appellate process and also in the federal court review process, the issue is not whether the defendant is actually innocent of the crime that he's been convicted of, but rather whether he was deprived of a fair trial.
They're not about innocence or guilt. They're about procedure and making sure everyone followed the law on both sides. It's about making sure that people get a fair trial. To understand Richard's process, we'll need to understand how the appeals court works in Maryland and how it worked or didn't work for Richard. Right after the break. I'm Brooke, and this is episode 8 of Convicted. Blue Apron is on a mission to make incredible home cooking accessible to everyone. They've established partnerships with over 150 local farms, fisheries, and ranchers across the United States. So they have beef, chicken, and pork that come from responsibly raised animals. Their produce is sourced from farms that practice regenerative farming. Plus, because Blue Apron ships the exact amount of each ingredient required per recipe, they're reducing food waste. It can also save you money. Those who spend a lot in restaurants or at high-end grocery chains can now spend under $10 for a delicious meal. My all-time favorite Blue Apron meal was just this week. I made the meatball pizza with fresh mozzarella cheese and charmed tomatoes. The girls I was babysitting loved it, and they don't love anything. Check out this week's menu and get your first 3 meals free with free shipping by going to blueapron.com/convicted. You'll love how good it feels and tastes to create incredible home-cooked meals with Blue Apron. So don't wait. That's blueapron.com/convicted. One more time, blueapron.com/convicted. Blue Apron, a better way to cook. In Maryland, the Court for Criminal Proceedings is separated into 2 parts, the District Court and the Circuit Court. Serious cases like Richard's are heard in the Circuit Court. In this system, procedure is so important. Everything has to be done by the book to make sure that everyone gets justice. If someone loses and they want to file an appeal, they have to take it to a higher court. For example, when you're a child and you want ice cream, you don't ask your siblings. They can't get it for you. They're on the same level as you. You ask mom. In Maryland, the Court of Special Appeals is mom. The Maryland Court of Special Appeals is an intermediate appellate court between the Circuit Court and another court called the Maryland Court of Appeals. It generally hears cases in panels of 3 judges. A total of 13 judges make up the whole of the Maryland Court of Special Appeals. The Maryland Court of Appeals is the state's highest court. There are 7 judges on that court, and all 7 preside together over all of the cases. The Maryland Court of Appeals chooses the appeals it thinks are life-altering, or more like law-altering, and typically these are cases that present new legal situations, something that could possibly set a precedent that could affect future judgments. In some cases, though, they can choose to hear a case directly, without it first going through the Maryland Court of Special Appeals. If the Court of Special Appeals is mom, then the Maryland Court of Appeals is grandma. If a side believes they were legally wronged, then they have 30 days to file a notice of appeal with the Maryland Court of Special Appeals. Basically, it's just a one-liner filed within 30 days with a fee. Then the Court of Special Appeals chooses which case it wants to hear oral arguments for, and the rest are decided based on the information in the briefs. During oral arguments, each side presents a 20-minute argument to that panel of 3 judges. Once it's done, they'll deliberate and make a decision. Sometimes that takes a long time. If the Court of Special Appeals denies an appeal, a person can appeal their appeal. The Court of Appeals accepts only a very small percentage of all petitions. If they find that someone does have a unique legal issue and determine a review is beneficial and in the public interest, the court will hear the case. Then both sides will argue in front of the Court of Appeals in a manner similar to the procedure for the Court of Special Appeals. If this is denied, however, the next option is to file a petition for post-conviction relief in the court in which the person was convicted. So, if a person started in circuit court, like in this case, they would go back down to the circuit court to file its petition. Basically, you've gone from grandma back down to your siblings. The post-conviction review petition must be filed within 10 years of the date of sentencing. You have a right to 1 post-conviction hearing per conviction. In Maryland, if you're incarcerated, you automatically qualify for post-conviction services and legal representation from the Post-Conviction Defenders Division of the Maryland Office of the Public Defender. Additionally, if there's a conflict or some other reason that a person is not able to get an attorney through this method, attorneys can be appointed.
Under what's called the Criminal Justice Act panel, which sometimes provides payment to lawyers on the panel at a rate of about $90 an hour, so at that very reduced rate.
The state's attorney must then file a response within 15 days after they're notified of the filing, and a judge other than the trial judge must hear the arguments. At this hearing, evidence can be submitted in the form of an affidavit, deposition, oral testimony, or any other form that's found to be convenient and just. The defendant has a right to be at all hearings related to this petition. The judge then prepares a statement, separately, addressing each ground that the petition was based, the federal and state's rights involved, the court's ruling with respect to each ground and reason for the action taken. This statement will be accompanied with the order to either grant or deny relief. If the judge finds in the person's favor, they can schedule a rearraignment, retrial, correction of sentence, or address any other matters. If post-conviction relief is denied by the circuit court, there is one more option in Maryland, to ask the Court of Special Appeals to review the ruling of the circuit court by filing an application for leave to appeal. The application must allege that the court erred in denying post-conviction relief and what those errors were. After your application goes to the Court of Special Appeals, the 3-judge panel reviews the application. The state isn't required to file a response to the application. However, the court might require them to do so if they think it would be helpful. They have a few options: deny your application, grant your application, but then uphold the decision by the lower court. They could also grant your application and then reverse the lower court's decision. Or they might grant the application and remand it back down to the lower court with instructions. Or finally, they may grant an application and order further proceedings as needed. As you can imagine, this ruling takes a long time, sometimes as long as several months. Then the person is notified of the decision in writing. If this is denied, you have no further appellate options in Maryland State Court. The only other option now is to file a federal habeas corpus petition in the U.S. District Court, a federal court, for the district in which you were convicted. In this case, the District of Maryland. Richard Nicolas was convicted of first-degree murder and the use of a handgun in the murder of his daughter Asia. On September 11, 1997, he was sentenced to life in prison without parole, the highest sentence you can receive in Maryland. He immediately appealed this guilty finding to the Court of Special Appeals. They affirmed his convictions and filed their opinion in December of 1998. His next option was to appeal the next higher court, the Maryland Court of Appeals. Richard filed a petition for writ of certiorari, basically asking the higher state court to review the decision by the lower court, the Maryland Court of Special Appeals. The Court of Appeals denied his petition in April of 1999. In July of 1999, Richard Nicolas filed a petition for post-conviction relief in the Circuit Court for Baltimore City. He wrote and filed the petition on his own, but it was later supplemented by the Maryland Office of the Public Defender in November of 2004.
I've actually worked on my case in here so hard that it's turned into a marketable skill inside of here. Now I'm a legal aid over at the law library, and I had started that over at the previous institution where they had me. I've earned a correspondence paralegal certificate through Blackstone paralegal studies.
He was finally given a post-conviction hearing in October of 2005. During his post-conviction hearing, Richard was represented by Michael Beach, whom I've never met, but I feel like I know after sifting through his notes. Mr. Beach told the court that he had 4 allegations and then a 5th to tie those 4 together. I have the transcripts, but no audio. For the state at this post-conviction was Roberta Siskind. Remember her? She was Sharon May's co-counsel at the trial. Mr. Beach's first 3 allegations spoke to the effectiveness of Richard's trial counsel. He brought up what he referred to as a dual inferences instruction. Basically, the jury was instructed to find Richard Nicolas guilty based on a large amount of circumstantial evidence. The state had not met their burden of proof. Arthur Cheslock, the same attorney that had been by Richard's side when they said guilty, testified at this hearing. There was an affidavit from Howard Cardin, specifically that Christina Gutierrez was either not paying attention when this error occurred or that she had accidentally put in that instruction to the jury. Realizing later that it was a serious error, counsel argued that it would be reasonable to infer that the jury, without the confusion, may have come to a different conclusion. The second allegation argued during this hearing was on the cause of lividity. Richard's counsel asserted that the original medical examiner, Dr. Shute, had testified that lividity was fully fixed at the autopsy after 13 hours and that it was visible on the left side. No mention of the fact that it was also visible on Asia's back. If there was no lividity on her back, she was clearly moved. Michael Beach went to say counsel had argued that the defense in this trial should have called their own witness to offer a rebuttal to the testimony, or they should have caught the error and cross-examined the medical examiner regarding his obvious mistake. At the trial, Sharon May had argued that Asia was picked up by Richard at 6:15 p.m. But the photo booth pictures. Asia had been alive at 7:03 or 7:47 that evening. She was pronounced dead at 10:01 p.m. This equates to 3 hours and 46 minutes. For lividity to be fixed by the time she was pronounced dead, she would have had to have been killed well before she was even picked up for the movie. The original testimony by the medical examiner at the trial was that it only takes 2 hours for lividity to become fixed on a child. And at this hearing, Mr. Beach produced his own expert, though his testimony left me feeling a bit confused. And the third allegation of the ineffective assistance of counsel was...
Juror number 72.
Juror number 72. Remember that guy? The guy who, after a fair amount of pressure from the judge, guessed he could be fair? The guy who became the foreman of the jury? Mr. Beach said that the defense should have stricken this clearly biased juror. The juror said he thought that the defendant was probably guilty. Mr. Beach said that they should have stricken him, and they had strikes to spare. The fourth allegation was labeled a Brady violation, but not for the reason that you think. It was actually about GSR and contamination issues. You see, the Baltimore police station that Richard was taken to had an issue. It just hadn't been discovered yet. It was right on top of a firing range and was practically covered in GSR. Everything was contaminated. The buckets, the sinks, the officers, their clothes, their uniforms, their desks. In the case where the issue was discovered, Tyrone Jones, he had a small amount of particles that could have been GSR in his hand. But the strength of the evidence was misrepresented by Van Gelder, the same person who conducted the GSR test on Richard's hands. Richard could have gotten those 10 particles just by shaking someone's hand before an interrogation. They could have come from anywhere. Mr. Beach promised a fifth allegation to tie the others together, and it was this. He asked the court to consider if the 4 errors he mentioned previously had together prejudiced the jury, or if there was a reasonable probability that the jurors would have reached a different conclusion had they had that evidence. I don't know Michael Beach, but when I read the words on the transcripts and letters from the boxes, he comes across as aggressive, a go-getter, the kind of man my mom wishes I would marry. I'm also biased in that I've seen some strongly worded letters between Mr. Nicolas and Mr. Beach. I don't think he liked Richard. They weren't friends. They wouldn't have sat and had a beer together. What I'm trying to say is, I think Michael Beach was trying very hard to win this case. Not just for his ego, but because he believed he was right. He didn't have the burden of innocence or guilt, just the hindsight that came after the trial. Mr. Beach's job was to establish deficient performance by trial counsel that made it reasonably probable that Richard was convicted as a result of that deficiency. Avoid the hassle of the post office and mail everything from postcards to envelopes to packages, domestic or international. Create your Stamps account in minutes online with no equipment to lease and no long-term commitments. You just click, print, mail, and done. Unlike the post office, Stamps.com never closes. I can print postage for any letter or package or a swag bag 24 hours a day, 7 days a week. Stamps.com brings all the services of the U.S. Postal Service right to my fingertips. It's right here on my desk next to me. Buy and print U.S. official postage for any letter, any package, any class of mail using your own computer and printer. Stamps.com makes it easy. They'll send you a digital scale that automatically calculates the exact postage you need. Stamps.com will even help you decide the best class of mail based on your needs. I use Stamps.com because I'm busy and it saves me so much time and so much money. And it's like the post office is just there whenever I need it. It's amazing. And right now, you too can enjoy the Stamps.com service with a special offer that includes a 4-week trial, plus postage, and a digital scale without long-term commitments. Go to Stamps.com, click on the microphone at the top of the homepage, and then type in convicted. That's Stamps.com, enter convicted. Stamps.com. Never go to the post office again. Roberta Sisk encountered Mr. Beach point by point. She began with GSR. She said that, in fact, it was not ineffective assistance of counsel that claim belonged, but rather prosecutorial misconduct. She also said that if Mr. Beach was, in fact, implying such a thing, this was not the right court to do so. She backed up her claim with the fact that it was in 2001 when the abundance of GSR evidence had been discovered. How could they be ineffective if they didn't have the precedent? Miss Siskin goes on a rampage standing behind the validity evidence. I asked my friend Lainey to read it for you.
I find it interesting that in hindsight, they're looking back to something that certainly was a piece of the case, but wasn't the only piece that indicated that this defendant was lying. The defendant testified himself. He put a time frame out there of 12 minutes. He made his attorneys deal with the defense that they had no opportunity to do anything else with. Their own expert talked about bloodletting in terms of how it possibly the victim would have been in that position in the car for a while. The jury indicated that they perked up at that and asked, what does he mean? They tried to clean it up in cross-examination in terms of, well, the blood's going to come out in 10 to 30 minutes, and then he came down to 5 minutes, but he really was not able to tell how long. All of the state's witnesses testified to the fact that when they got there at the scene that the victim, the blood was dry, and that which also is supported by the fact that she wouldn't have died in that short amount of time. And that isn't the only evidence. I mean, there was tons of evidence here. There was the defendant's own story. Not only did he put a 12-unit time period in this case, but he talked about a phantom driver, talks about an individual who is coming behind him on a main thoroughfare and is too close to him. He's concerned, so he turns off the street that has no buildings on it after passing highly lit McDonald's, Texaco station, various other places that he could have gone. But he goes on this unlit street with no homes, pulls off it, pulls to the opposite side of the road, said he gets out of his car to confront this phantom driver who has bumped him twice, and gives a very vague, broad description, even though he had seen this car for a while on the road, of a car, a dark car, and a white male.
She said a lot, but a lot of what she said wasn't very accurate. She also goes on to talk about 72, the foreman, how he did come back and say he could be impartial. He didn't, though, not according to the transcripts. Mr. Brown, if you're listening to this, I'd really like to talk to you. She also said the jury instruction wasn't as big of a deal as they were making it out to be. I mean, come on, there were a lot of instructions. The jury had to consider them as a unit. I don't get it. I would think every instruction was important, but maybe I'm not supposed to get it. Less than a month later, the circuit court made its decision and denied Richard post-conviction relief. When I read the court's decision, it looked very much like the written document that the prosecution had submitted, like maybe even parts of it had been cut and pasted. Richard's final attempt to appeal at the Maryland state level was to submit an application for leave to appeal with the Maryland Court of Special Appeals. Again, essentially formally asking them to review the lower court's decision. This application was denied in March of 2006. At this point, he had spent nearly a decade in prison. In October of the same year, his next option was to file a federal habeas corpus petition, which isn't considered an appeal, and it goes to the U.S. District Court for the District of Maryland. He filed a petition for a writ of habeas corpus, once again pro se, by himself. A habeas corpus, according to the evidence prof, Colin Miller, literally means you have my body. It asks the court to force the prison to deliver the inmate to the court and provide a valid reason for their incarceration. I'm going to introduce you to someone new, though you've heard his voice before.
My name is Jeff Garanther. I'm at a law firm, Venable, where I chair our litigation division. I've been a lawyer since 1984.
Jeff's going to tell you about his involvement in Richard Nicolas's case.
When I was a federal prosecutor from 88 to 93, my boss, the U.S. Attorney from Maryland, during the last part of that 5-year period, was a guy who's currently a federal judge, Richard D. Bennett, here in Maryland. He and I have remained friends, and I think we were at a law club dinner, which sounds terribly exciting, I know. It's a gathering of lawyers, judges, and practitioners where one of you, after dinner, talks about some new case or some interesting area of the law. And Dick said to me, I think at a law club dinner, I've got a case where I feel like there was a Brady violation that I'd like to bring you into. And I think that was about maybe 5.5 years ago.
The judge reviewing his petition, Judge Bennett, was so compelled by Richard's argument that he appointed counsel to represent him for this petition. That's not required in the state of Maryland. Richard could have continued to represent himself, but the judge said that he believed that this could be a case of actual innocence. Jeff, Rachel, and I were sitting in a beautiful conference room in a large, gorgeous building in Baltimore. When I asked where the funds came from for this case, he told me that sometimes his firm acts completely pro bono, or sometimes they're able to get funding through the Office of the Public Defender. He noted that they were reimbursed at a rate of around $90. It sounded like a lot to me at the time, but having gained some life experience since then, I realized what a small percentage of his regular fee that must have been. I asked Jeff to tell me more about his original impressions of the case. Basically, what did he think when he was at the point that we are now?
You know, I've not done a lot of post-conviction work on the defense side. When I was a prosecutor, I had to defend some convictions that went up in this way. So there was a lot of it that was new to me. But I remember focusing almost immediately on the Brady violation, and part of that was because Judge Bennett felt so strongly about it. And I'd known him as a prosecutor, and we took Brady very seriously. And in his particular case, he would actually have the government produce in his chambers evidence so that there wasn't any question about it. So had Richard Nicolas been tried in Richard Bennett's courtroom, this case never would have turned out the way it did. This evidence would have been produced right in the beginning so that there would be no question about it down the road.
The first step was to file a habeas petition. Having done his own legal work for so long, I wonder what that felt like for Richard. Did it feel the same as when I feel when someone else is editing my voice? Calming because they probably know what they're doing, but also anxiety-provoking, like I've lost some kind of control? I have the SeatGeek app on my phone, and it's by far the easiest way I found to shop for tickets. I can be anywhere, and with just a few taps, I can instantly find seats. I actually just used SeatGeek to buy tickets to Wicked right now. SeatGeek is designed to make your ticket buying experience easier than ever. They save you money and time by searching multiple ticket sites to compare prices and find amazing deals. And you get the most bang for your buck. SeatGeek grades every ticket based on value to help you immediately identify the best seats that fit your budget. Plus, every purchase is fully guaranteed, so you can shop for tickets on SeatGeek with confidence. Make SeatGeek your go-to app for finding the best deals on every type of ticket, from sports and concerts to comedy and theater. I'm going to spell it for you one time because I know I say that word a little funny. SeatGeek. SeatGeek. Best of all, my listeners get $20 off their first SeatGeek purchase. Just download the SeatGeek app and enter promo code CONVICTED today. That's promo code CONVICTED for $20 off your first SeatGeek purchase. They present that the gunshot residue results were unreliable due to likelihood that GSR came from the station or the officer's hands. And it was also revealed that the officer who came into physical contact with the defendant was not wearing gloves for a period of time. They also said it was irrelevant admission of the fact that the defendant was a gun owner. The jury didn't need to know that. Remember all the steps that it took for Richard to get to this point? It feels exhausting, which is ironic because that's what it's called when you've litigated an argument until it can't go any further. The issues presented to the federal court had to have been exhausted by the state lower courts, pushed until they couldn't go any further. So the problem with this argument is that the issue of GSR wasn't exhausted, and therefore it couldn't be presented in this habeas proceeding. It was considered new evidence. So they pushed pause. Judge Bennett stayed the habeas until the circuit court could rule on the matter of GSR. So at this point, Richard filed a motion to reopen the post-conviction case in Baltimore City Circuit Court because of the gunshot residue issue, so it could be decided and exhausted.
The shorthand for it is GSR, gunshot residue evidence, which at the time in the late 90s was used all the time by the city state's attorney's office in prosecuting cases, by prosecutors everywhere in the country. And it was considered fairly determinative. If you had gunshot residue, that suggested pretty strongly that you had fired a gun. Well, as it turns out, if you or I were taken into a police station now, there's especially one that has a firing range, there's so much gunshot residue around that we would have trace amounts. And in fact, I think it was the case that Richard had been taken to one of these police barracks that had a firing range, but for whatever reason, the amount of gunshot residue they took from his hands might have been those sort of trace amounts. It should not have been admitted at trial. And the city state's attorney's office had, at some point after the prosecution, stopped using this evidence for that very reason.
His claim was denied, so they went back to the federal court with new information. They also went back with a hunch that the prosecution had failed to release some vital information to the defense. Richard's team filed a motion for discovery to determine if there was, in fact, evidence in the file that hadn't been revealed. In a memo of opinion dated January 25, 2012, by Judge Bennett, he says that 1. The state withheld the names of 2 possible exculpatory witnesses. 2. A transcript of the police interview with one of the witnesses was not disclosed to the trial counsel. And 3. Although the police had subpoenaed the records for the hotel where the witnesses were staying, they didn't contain the warrant return. Also, Rachel Kamens had talked with one of the lead detectives, and she suspected that the police or the state might have additional information about the victim's whereabouts on the night of the murder. And Judge Bennett grants the motion. Judge Bennett held an in-camera review. That means he looked at all the files with the attorneys in his chambers. During the course of this review, 2 potential witnesses were discovered, and their existence had not been made available to anyone other than the prosecutors or the police. Remember in episode 7 when I told you about the 2 witnesses? I promised more, and here it comes. But first, just a few housekeeping items. We're going to end this episode after talking about the roles or potential roles these witnesses could have played in the case. In the upcoming episodes, we're going to talk more about the proceedings that have become Richard's journey through the legal system. During the week that begins August 28th, we'll have our final discussion episode. Then, on September 11th, the 20th anniversary of Richard being sentenced, we'll have the last episode, an episode about the future, about what possibilities might lie next. And if you're still with me at this point, in that last episode, I'm going to talk about my opinion, or opinions, on innocence or guilt. Just keep in mind, that's not the point of any of this, but a lot of people have asked. I mentioned before that there were two witnesses that could possibly have been exculpatory in this case, evidence that could have benefited the defense in a trial-altering way. Their names are Benson and McKenzie. McKenzie had talked to the police the day after Asia's murder, but the only record I have is a one-page summary signed by Detective Gordon and Detective Massey. Upon our arrival, we met with Miss McKenzie, who advised her vehicle was parked on the parking lot of the Holiday Inn, which is in Frankfort Avenue. She advised that she was going to her vehicle and observed a small vehicle at the bottom of the hill. As she was entering her vehicle, she hears a loud popping sound like a gunshot. Mrs. McKenzie advises that she was exiting the parking lot and the car sped off. When Mrs. McKenzie returns from the store and parks her vehicle approximately in the same parking space, she observes the same vehicle at the bottom of the hill, with the parking lights on and the inside dome light on. At this time, she returns to the hotel room. I don't know how they knew to talk to Miss McKenzie. It's unclear. But they did. The day after Asia was murdered. The day that they arrested Richard for that same murder. There's no evidence of further contact after that. I don't know what the police were doing in that time, but the next time that there is any evidence of contact at all is in September, when a subpoena was submitted to the Holiday Inn for McKenzie and Benson's records. I have to wonder, because no one I've talked with has the answers, as to why after 2 months after they had got their guy, the police were still investigating this lead. I believe the police thought Richard was guilty. Actually, I prefer to believe that the police thought he was guilty. It's easier for me to believe that they cut corners to make their city a safer place, rather than just to add check marks in the win column of their scorecards. In January of 1997, Richard Nicolas had been arrested and charged with the murder of his daughter for 6 months. Also, in January of 1997, the police brought Mr. Benson in for questioning. If I hadn't peeked, I would have no idea who Mr. Benson was. But I'll fill you in. He was Mackenzie's romantic partner, and they had been together at the Holiday Inn that night, the night of Asia's murder. Here's part of the interview. Sorry for the sound quality. Picture winter in Baltimore, the heat blasting, and a couple of men huddled around an old-school tape recorder.
So, as I walked around to the driver's side, I just kind of kept a unsuspicious eye, I guess you could say, on the car, you know. And I saw the dome light come on, and it looked like, I don't know if he was reading something, or it kind of looked like he was reading something, is what it would have looked like. And then, I guess like maybe a half a minute later, I was just standing at my door with my key in the door in the keyhole, and I opened my door and kind of like cracked my door, did opening because I didn't want the dome light to come on in case he actually didn't see me at that point. And I was still kind of just watching over the hood of my truck, which sits really high, so really the only thing I see coming over the hood of the truck is my head, you know. And I saw this flashlight and heard a bang, but I didn't know what it was. I mean, I didn't know if it was, because it's, I don't know, it's just like when I turned my head and looked at it, I guess it was when it was really happening.
Okay, so you saw a flashing light and a bang. You heard a loud noise.
Right. I thought the light came from inside the car, but I didn't know, and I didn't know if maybe it was a dome light or what it was. I really didn't know.
Okay, and the loud bang sound like what kind of noise to you? Did it sound?
It sounded like a car was blowing up, is what it sounded.
Sound like a car was blowing up?
Yeah, it was really loud.
And then after that, after you heard the loud bang, then what happened?
It's interesting to me that both of these witnesses talk about a noise that could have been a gunshot, but also talk about a car near the hotel. The sights and sounds put together don't match Richard's story. Sometimes our brains make connections between the senses that aren't entirely accurate. We want to make sense of things, like a light and a sound. Keep that in the back of your mind. It'll become important in a later episode. Benson talks about seeing a car acting disoriented. Mackenzie mentions it too. They describe the car's eventual path as leading down Bowley's Lane. Benson says at one point he was following this car. It's also confusing to me. I can't quite picture how this all fits together. Didn't Mackenzie say she was alone? That's it. That's the last contact in the files between the police and either Benson or Mackenzie. I don't know what effect these two individuals would have had on the trial, but that's the point. No one knows the answer to that because the defense never had the chance to talk with them or introduce them to the jury. I wish I could have been a fly on the wall in Judge Bennett's office during his review. I wonder what his feelings were when the realization hit that.
And this is pretty clearly a Brady violation.
I mean, a loud noise consistent with a gunshot at the time the defendant said there was a shooting seems like something you would want to walk on the safe side of. I don't know. And the prosecution isn't talking. The problem with this evidence is that the witness's very existence was just discovered in the federal court review. So how could that issue have been exhausted at the circuit court level? It couldn't. So again, the habeas was stayed, and the case of Richard Nicolas crawled back down to the circuit court, which is where we'll pick it up next time. I'll see you next week. I'm Brooke. Thanks so much for listening. You can see pictures, download the transcripts, and view other documents at convictedpod.com. The music was created by musical genius Blake Maples. You can see and hear his work at blakemaples.com. Additional help was received from TJ Cunahan, Rachel Kamens, and Heidi Galore, and Lainey from True Crime Fan Club podcast.
Hey guys, it's Lainey, host of the True Crime Fan Club podcast. If you're a true crime addict like I am, then my podcast is for you. It's a podcast for the ultimate true crime enthusiast, giving you a glimpse into the life and crimes of the most demented minds. You won't want to miss an episode.